Do you have questions about divorce? In this video, I will answer 5 frequently asked divorce questions. Also, stay tuned until the end for the Christian perspective and a special bonus. Christian attorney R.L. Johnson, lawforlife.us. In my practice as a trial lawyer, I've litigated over 100 divorces. Along the way, I've noticed that clients tend to ask similar questions at the onset. So in this video, I will answer 5 commonly asked divorce questions. But first, the pop quiz. Is it true that 50% of all marriages end in divorce? Close, but not quite. According to the Center for Disease Control, in the year 2000, there were about 41% fewer divorces than marriages. And in 2018, there were about 37% fewer divorces than marriages. It's also noteworthy that marriage rates in the United States have declined gradually over the past 18 years. So have the number of divorces and annulments. Nonetheless, nearly 800,000 Americans every year get divorced, which is an alarming number. However, the good news is that the trend in the United States is steadily decreasing with regard to divorces. Now, before tackling the frequently asked divorce questions, we have to define the term marriage. There are 2 kinds of marriage unions. There's a legal marriage and then there's a common law marriage. Well, what's the difference? Well, state law controls the determination of whether or not a marriage relationship of either kind exists between 2 people. Moreover, the domicile, that is where people actually live, is what usually dictates which state's law applies. So a legal marriage is defined by the existence of a valid, state-issued marriage license, a solemnization ceremony, or both. By contrast, not all states have statutes defining common law marriage. In these instances, case law, that is, judge-made law, and public policy determine the validity of a common law marriage. Well, why is this distinction crucial? The distinction is crucial because if you're seeking a divorce in a state that has a strong public policy against common law marriage within its borders, you may discover that you can't file for divorce in that state because the state simply does not recognize your marriage. As a matter of fact, only 10 states in the Republic, the District of Columbia, and some federally recognized Indian tribes recognize common law marriages established within their borders. Further, each state in the Republic that recognizes common law marriage has a slightly different test to determine validity. But generally, there are 5 elements relevant to any determination of a common law marriage. The 5 elements are capacity, agreement, cohabitation, holding out, and reputation. If you'd like more information about the topic of common law marriage, click the link in the description box to obtain a free e-pamphlet that more fully explains this topic and more. Now on to question 1. Can I have my marriage annulled? The short answer is probably not. The long answer is it depends. An annulment occurs when a judge determines that a valid marriage never took place. Many couples who have religious, spiritual, ideological, or principled objections to divorce will attempt to seek an annulment. Typically, an annulment occurs in 2 instances. The first is when the marriage is void. The Latin term for this is void in initio. This means that it was legally impossible for the parties to have married in the first place. Examples of void marriages include bigamous marriages, marriages prohibited by the relationship of the parties, for example between siblings, or marriage with a person who is not capable of contracting for marriage, for example someone under the legal age of consent. If the marriage was legally impossible, it never happened. As such, theoretically, no legal process is needed to end it. However, the parties may need a court to settle property or child custody disputes. Additionally, unless and until there's a judicial determination that you were never married, the public records will reflect that you are in fact still married. The second instance in which an annulment occurs is a voidable marriage. These are marriages that are valid until the court says otherwise. Voidable marriages are brought in instances in which a party later discovers that the marriage was contracted upon a fraud, a mistake, or a hidden impossibility. For example, infertility or impotence. Whether or not your marriage is voidable will turn on your state's statutory and case law. Thus, before going down this sparsely traveled road, you must ensure that there's a legal basis for doing so. Question number 2. What is the difference between a divorce and a legal separation? A divorce is a legal dissolution of a marriage. A legal separation, on the other hand, is an arrangement by which a couple remain married but live apart, following a court order. This is commonly referred to as an order of separate maintenance or a legal separation. Presently, only 42 states have statutes that specifically address or provide for legal separations. So why do some people opt for a legal separation instead of an outright divorce? Well, many couples have religious, spiritual, ideological, or principled objections to divorce and seek a legal separation as an alternative to divorce. Indeed, Christians citing Matthew 19:9 and Mark 10:10 often point out that Jesus hates divorce. This is the Christian perspective, which I will revisit towards the end of this video. Additionally, persons in domestically violent marriages may also opt for a legal separation. I'll also return to this specific issue momentarily. So how does one commence a legal separation case? A complaint for separate maintenance or legal separation mirrors a complaint for divorce, except that it does not allege that the objects of matrimony have been irreparably damaged, nor do they request that the court dissolve the marriage. As such, the parties remain married for religious, taxation, familial, or insurance purposes. Thus, with an order of separate maintenance or legal separation, an aggrieved spouse can ask the court to divide marital property, determine child custody, financial support, and settle any parenting time disputes without breaking the bonds of matrimony. If you'd like more detailed information about legal separations, click the link in the description box. Question number 3. What is a no-fault divorce? Most states require a showing of wrongdoing, that is, adultery, abandonment, cruelty, or mental illness, and/or a period of separation before divorce may be granted. However, a minority of states require no such showing of wrongdoing or fault. These states are aptly known as no-fault states. Irreconcilable differences is the most familiar ground for a no-fault divorce. But in its purest form, the only meaningful ground for a no-fault divorce is where even if the judge refuses to grant your divorce, you and your spouse would not live together as husband and wife. Presently, there are only 17 states that have no-fault divorce statutes. The link that I provided in the description box will take you to a list of no-fault states as well as a divorce law reference table for every state and U.S. territory. Question number 4. What if I don't want a divorce? Unfortunately, any person who wants a divorce will be able to obtain one over their spouse's objection. Indeed, many divorces are initiated by one party to the utter surprise of their spouse. In fact, I've seen defendants in divorce cases actually try to convince a judge that they can prove that the marriage is far from over. That is, that the objects of matrimony are alive and well. Unfortunately, this is usually followed by the judge asking the plaintiff, "If I don't grant your divorce, would you live with him or her as husband and wife?" If the plaintiff answers no, then the judge has no choice but to grant the divorce. Consequently, if you find yourself in divorce court against your will, seek both individual and family counseling to help you and any minor children safely navigate the troubled waters ahead and to keep you emotionally grounded throughout the process, which may get worse before it gets better. But trust and believe that it will, in fact, get better. Question number 5. My spouse is abusive. What can I do to protect myself during the divorce process? During the divorce process, both parties retain an equal share in the marital estate. The marital estate is property including debts acquired by either spouse after the wedding. In short, this means that among other things, both parties have an equal right to remain in the marital home until there is a mutual agreement of the parties setting forth who leaves and who stays, or until there's an order of the court concerning marital property. However, if God forbid your spouse has become emotionally abusive or physically aggressive, you must take immediate action after the first occurrence. This is crucial, especially if minor children are in the home. Indeed, note well that awareness that your child is being subjected to emotional abuse and doing nothing about it may be considered by state authorities as a failure to protect and grounds for state intervention. Now, in the case of an emotionally abusive spouse, a brief respite away from the verbally abusive or toxic spouse, followed by a period of marital counseling and possibly family counseling may suffice. If it doesn't, then a legal separation may be in order. By contrast, in the case of a physically aggressive spouse, you must seek the support of law enforcement and the courts immediately. Generally, law enforcement and the courts draw the line between a domestic dispute and domestic abuse at the point where an act or conduct imposes on or interferes with personal liberty or causes a reasonable apprehension of violence. When this line is crossed, police need to be involved and someone, preferably the aggressor, needs to leave the home until such time as that reasonable apprehension of violence disappears. However, if you believe that the aggressor will not leave or stay away voluntarily, then you need a personal protection order, sometimes referred to as a PPO. A PPO is an injunctive order that protects you from domestic abuse or stalking by the aggressor. Now, a quick word about an ex parte PPO. Ex parte is Latin for from a side. This means that the court order of protection will take effect immediately without a hearing or advance notice to the aggressor. To get an ex parte order, you must show the judge that an immediate and irreparable injury, loss, or damage will result from the delay required to give the aggressor notice, or that the notice itself will cause hostile action to be taken before the PPO can be issued. This is an essential tool because in non-emergency situations, a hearing to which the aggressor is invited to attend must take place before the PPO will be issued. Thus, if you're in immediate danger, you may request an ex parte PPO. And there you have it, 5 frequently asked divorce questions and answers. Now for the Christian perspective. As I mentioned earlier, many couples object to divorce on the ground that Jesus hates divorce, which is true, and as an offer of proof, Christians usually cite Matthew 19:9, where Jesus says, "And I say to you, whoever divorces his wife except for sexual immorality and marries another commits adultery." Christians also cite Mark 10:11-12, which says, "Whoever divorces his wife and marries another commits adultery against her. If she divorces her husband and marries another, she commits adultery." For additional support for the objection to divorce, some Christians also cite 1 Corinthians 7:10-11, where the Apostle Paul instructs that, "To the married I give this charge, not I, but the Lord. The wife should not separate from her husband, but if she does, she should remain unmarried or else be reconciled to her husband. and the husband should not divorce his wife. These statements, properly understood, are illuminated by their ancient context. In ancient Rome, marriage was a public and sacred duty, the primary motive and justification for which seemed to be to become a father. However, under Jewish law, marriage was mandated by Genesis 2:24, which says, "Therefore a man shall leave his father and his mother and hold fast to his wife, and they shall become one flesh." However, under Jewish law, it was also the case that Deuteronomy 24 provides that divorce is permissible if then a wife finds no favor in her husband's eyes because he has found some indecency in her. Indeed, the two prominent schools of thought at the time were to the House of Halal scholars, who believed in divorce for any cause, and the House of Shammai scholars, who believed in divorce only in cases of adultery. Consequently, this debate compelled the Pharisees to test Jesus by asking, is it lawful to divorce one's wife for any cause? Matthew 19:3. The Pharisees argue that if divorce was illegal in God's eye, why then did Moses command one to give a certificate of divorce and to send her away? Matthew 19:7. To which Jesus concluded, because of the hardness of your hearts, Moses allowed you to divorce your wives. But from the beginning, it was not so. And I say to you, whoever divorces his wife except for sexual immorality and marries another commits adultery. Matthew 19:8-9. Thus, as biblical scholar David Instone Brewer points out in his books Divorce and Remarriage in the Bible and Divorce and Remarriage in the Church, the any cause divorce was invented by some Pharisees who divided up the phrase a cause of indecency, Deuteronomy 24:1, into two grounds for divorce: indecency, the Greek term for which was porneia, which they interpreted as adultery, and a cause divorce, that is, any cause. However, Jesus said that the phrase could not be split up and that it meant nothing except porneia. At that time, almost everyone was using this new type of divorce, but Jesus told them that it was invalid, so remarriage was adulterous because they were still married. So the takeaway is this: Jesus instructs that a couple should remain married as indeed God was a witness at their wedding. However, Jesus also recognized that when there's a real hardness of hearts, parties may need a divorce. Finally, as promised, as a free bonus, I will send my e-pamphlet, which contains an overview of the topics covered in this video, to everyone who clicks the link in the description box, which will take you to our blog, lawforlife.us. Thank you for watching, and if you find this content useful, please let me know what you think in the comments section, and let me know if you have any questions or suggestions on future videos. Also, be sure to subscribe and hit the notification bell so that you won't miss any upcoming content. If you're looking for legal content that's accessible to real people, be sure to join us online at lawforlife.us, where we profess the truth that we can do nothing without God.